Hi everyone, in today's video I have an update to share with you regarding the EB5 Investor Visa Program. USCIS has appealed the decision of the District Court which set aside the EB5 modernization rule. This was that decision back in June which lowered the EB5 investment amount to $500,000. In this video we're going to talk all about this news, so make sure to stick around. Hi everyone, my name is Michael Ashoori and I'm a U.S. immigration lawyer based in Los Angeles, California. At my law firm, we work with clients from all 50 states and worldwide, and we regularly post videos to keep you up to date with the latest immigration news. So if you haven't yet subscribed to our YouTube channel, make sure to hit the subscribe button. Also, please make sure to give this video a big thumbs up so that YouTube knows to share this information with more people. So as I mentioned, in today's video, I have an update to share with you regarding the EB5 Immigrant Investor Visa Program. So USCIS has appealed the decision of the District Court, which ultimately resulted in the EB5 investment amount being reduced to $500,000. So let's start off with some background information regarding what's going on. Well, back in June, based on a lawsuit that was filed by Behring Regional Center, a federal court set aside the EB5 modernization rule. This was a law that increased the required minimum investment amount to qualify for an EB5 visa from $500,000 to $900,000. So in its lawsuit, Behring Regional Center made multiple challenges against the EB5 modernization rule. Among those challenges was that the Secretary of Homeland Security was not properly serving in his role when he promulgated the EB5 modernization rule. Well, the judge overseeing the case sided with the plaintiffs and ultimately set aside the EB5 modernization rule. And what this ultimately meant was that the minimum investment amount for EB5 was lowered from $900,000 back down to $500,000. This was wonderful news for thousands of EB5 investors. And when this news broke, many of us were wondering, how would USCIS respond? Would USCIS accept these changes? Would they attempt to appeal the decision? Or what types of steps would USCIS take? We were surprised and pleased to see that USCIS announced shortly after the decision that USCIS would begin accepting EB5 applications at the $500,000 investment amount while it determined what next steps it would take. And weeks went by with relatively no action from USCIS regarding this decision. That is until recently, when we've come to learn that USCIS has appealed the decision of the District Court. Now, something interesting about USCIS's actions is, first, USCIS waited a very long time to file the appeal. USCIS basically waited till the last possible moment before it filed its appeal. Another interesting thing is that USCIS did not file a motion to stay the decision of the lower court. A motion to stay the decision of the lower court would essentially be if USCIS asked the appeals court to temporarily stop enforcement of the decision of the lower court, which practically means that USCIS would ask the appeals court to temporarily raise the investment amount required for EB5 back to $900,000 while the appeals court decides the merits of the appeal. However, as I mentioned, USCIS did not file such a motion. USCIS did not yet file a motion to stay the decision of the lower court. Now, at this point, it's not exactly clear why USCIS has not yet filed a motion to stay the lower court's decision, or whether it's planning on filing a motion to stay the lower court's decision. It could be that the reason why USCIS has not yet filed such a motion is because USCIS is not confident in its ability to get such a motion approved. Perhaps because it would be challenging for USCIS to show that the requirements to get a stay approved are met. Now, what are some important takeaways for you if you're considering an EB5 investor visa? The first very important takeaway is that what this news means is that the clock is ticking. Ever since this news broke back in June that the EB5 minimum investment amount was reduced back down to $500,000. It was wonderful news, but we always knew that this would be for a limited window of time. This appeal being filed by USCIS is just another confirmation that this window of time is limited. Now, there are a number of things that we can see happen with the EB5 program going forward. One is we can see USCIS just wait and see what happens with this appeal, and basically wait for the appeals court to decide the appeal on the merits. Another potential development is that we can see USCIS potentially file a motion to stay the decision of the lower court. Again, as we mentioned earlier, this is not something that USCIS has done yet, but USCIS may decide to file a motion to stay the decision of the lower court. Another development that we could potentially see is we could potentially see the Secretary of Homeland Security enact the EB5 modernization rule, and this time do so properly, following all the correct procedural rules. And lastly, another thing that we can expect to see with EB5 is we can expect to potentially see Congress step in and attempt to pass comprehensive EB5 legislation. Again, right now the EB5 program is, relatively speaking, in a state of disarray. We have a situation right now where the Regional Center program has lapsed since June 30th. We also have various other issues with the EB5 program regarding fraud that takes place within the Regional Center program. We have issues regarding major disagreements in terms of what the EB5 minimum investment amount should be, and various other issues with the program. So we may potentially see Congress come in and attempt to pass a law which remedies these various issues and reauthorizes the Regional Center program and creates safety measures in place to protect investors against fraudulent programs, and also attempts to come to an agreement in terms of an EB5 investment amount that works for all parties involved. As of right now, there are a lot of people that feel that a $900,000 minimum investment is too high. Meanwhile, there's a lot of people that think that a $500,000 investment is too low. So we may potentially see a bill that attempts to modify the investment amount at some sort of a number that works for all parties involved. So there you have it. In this video, we talked about how USCIS has filed an appeal to the district court's decision to set aside the EB5 modernization rule. I hope you got a lot of valuable information from this video. If you know anybody that can benefit from this information, please feel free to share this video. We're all about empowering you with knowledge, so the more people that can see this video that can benefit from this information, the better. As always, thank you so much for tuning in, and I will see you on the next video.